Today I'm going to talk about what happens when you're arrested before you come before a judge and how do you bail out and things like that. When police are going to charge you with a crime, they have a couple options. One is to write you a ticket and let you go. Another one is to mail you a complaint. Or the third option they have is to actually arrest you and bring you down to jail and wait for the prosecutor to charge you. If they do that, the police can arrest you on probable cause and they can keep you in jail for up to 36 to 48 hours depending, at least here in Minnesota, and without you even being charged. And then if you're not charged by the time that 36 or 48 hours is up, they have to let you go unless they can show good cause to a judge as to why you should still be held. Weekends don't count for that 36 or 48 hours, so if you're brought in on a Friday night, the clock, that 36 or 48 hours doesn't start to count until Monday morning. So if someone's picked up on a Friday night, they might not even get in front of a judge until Tuesday or Wednesday. There's some things that can be done to speed that up. If you or your family get a hold of a criminal defense lawyer, a lot of times we can call the judge who's in charge of setting bail, and without you even going to court, we can get you released or get bail set without a court appearance in some cases, so that you don't have to sit for 1 or 2 or 3 days or 4 days even waiting to get in front of a judge. Sometimes people risk losing their job if they're in jail that long. So that's something you should try to do if you're able to. If you're taken into custody and you're given a bail hearing, what happens is after you're charged, you get in front of a judge. And the judge is going to determine whether they should let you go on your own and just give you another court date to come back, whether they should give you certain conditions like remain law-abiding, give random urine analysis tests if it's a drug offense, for example, or if it's a drinking and driving thing, they might put you on what's called a scram bracelet or an alcohol bracelet that goes off if you've been drinking. Those are special conditions they can give instead of setting bail for you or in combination with bail. They might say do not contact this person or go around them if it's like an assault case. There are a whole bunch of different conditions judges can impose if they don't want to give you bail, but they don't just want to let you go on your own. Of course, a judge always has the option to give you conditions plus bail or just straight bail. And the purpose of bail is only a last alternative for a judge, and some judges need to be reminded of that. But the purpose of bail is to assure that you'll come back for your future court appearances. And bail can run anywhere from a couple $100 on all the way on up to sometimes $100,000 or even $1 million, depending on cases. If you get bail set, you can either pay the cash in the amount that the judge sets for cash bail, or you can hire a bond company to post a bond for you. Bond companies typically charge 10%, and then they make you or your family pledge collateral to secure that loan from the bond company, basically. So if your bond's set at $50,000, a bond company would charge you $5,000 plus make a pledge collateral. That's their fee. They keep it. You don't get that money back. The bond company puts up a $50,000 bond to the court and promises that you'll come back, and they'll hunt you down if you don't, the bond company, because otherwise they're going to lose that bond. What a judge considers when you go before them at your first appearance before a judge on the bail hearing is things like how severe the crime is that you're charged with. Obviously, the more severe the crime, the more likely it is that judge is going to set a high bail. Also, have you been in trouble before? The more trouble you've been in, the more likely it is that the judge is going to set a higher bail. And then, how likely are you to come back to court? Things that judges think are going to make you more likely to come back to court are if you have family or friends in the area, if you've lived in the area for a long time, if you've got a steady job in the area, if you haven't been in trouble before, if you have been in trouble before but you've always made your other court appearances, if you're medically disabled and it's not likely that you're going to flee. All those sorts of things, and many others that they'll look at in determining whether or not you're likely to come back to court. Obviously, the less likely they think you are to come back to court, or the less ties you have to the community, the more likely they're going to set bail in order to make sure that you've got some cash out of pocket that you'll get returned to you as long as you come back to court if you're posting a cash bail. So those are some of the factors that a judge looks at when determining bail, again, with a whole other things. They'll also look at the weight of the evidence against you. Obviously, the more weight of evidence there is against you in the allegations, the more likely it is that you committed the crime in the judge's mind, the more likely it is that they're going to want to set bail on you. And then they'll look at other conditions because, again, if they don't have to set bond, they can just set conditions or let you out on your own. And hopefully, if you just follow those conditions, that's enough for the judge to be assured that you'll come back to court and make your future court appearances. You'll also have the right to be appointed a public defender or apply for a public defender if you cannot afford a lawyer. You have the right, of course, to consult with a lawyer and have that lawyer present at your bail hearing, or to get a lawyer before your next bail hearing. You're also informed a lot of times of the rights that you have, even at your first court appearance, including your right to be presumed innocent until proven guilty beyond a reasonable doubt, and your right to remain silent throughout your case, which is a very good idea at your bail hearing. You don't want to talk about what did or didn't happen in the event. You'll get that opportunity later. If there are no charges at the expiration of that 36 or 48 hours, the judge will usually release you if the county attorney or the prosecutor hasn't had time to charge you yet. But in most cases, they'll find a way to get you charged, and you're going to be dealing with either conditional release, being released on your own with another court date, or given a bond to post. This is the process in state court in Minnesota. The process in federal court is different. I'll make a different video about that. But in the meantime, if you have any questions, you can look me up on my website at www.arrestedminnesota.com, or you can give me a call. My name is Ryan Pacyga, and my number is 612-339-5844.